While government is seeking to approve legislation that will remove public officers from receiving non-contributory pension payments from the Consolidated Fund and instead require them to contribute to a pension plan through monthly contribution, on the same day it will be presenting a legislation for the approval of the House that will require for the pension of judicial officers to be charged 100% on the Consolidated Fund. Called the Eastern Caribbean Supreme Court Judicial Officers Pensions Bill 2024, the legislation is set to be presented and receive approval during the December 18th sitting of the lower house. This bill seeks to provide for the payment of pensions and gratuities in respect of the service of judicial officers of the Eastern Caribbean Supreme Court. Section 5 of the bill says, there shall be charged on and paid out of the Consolidated Fund all such sums of money as may from time to time be payable by way of pension or gratuity in pursuance of this Act and the Supreme Court order. The bill says that a pension may be granted under this Act to a judicial officer on his or her retirement from judicial office on or after he or she has served at least 5 continuous years of service as a judicial officer, and in one of the following cases: A. On attaining the retirement age, B. On the abolition of his or her office, or C. If he or she or a person appointed by the court to act on his or her behalf applies to the Commission in writing for him or her to retire on the grounds that 1. He or she is incapable by reason of any infirmity of mind or body of discharging the duties of his or her office, and 2. The infirmity is likely to be permanent and submits with the application medical evidence to the satisfaction of the Commission. The rate of the pension will vary, but in the case of the Chief Justice, if he or she has had continuous service as a judicial officer for a period of not less than 10 years, the pension is equal to the annual pensionable emoluments attached to the office of the Chief Justice, or 2, if he or she has had continuous service as a judicial officer for a period of less than 10 years, but not less than 5 years, the pension is computed on a prorated basis, calculated by dividing the number of years of continuous service by 10 years and multiplying the result by the annual pensionable emoluments attached to the office of Chief Justice. Reporting for GBN News, Beverly Tellisford.